Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning, everyone. I'm still so pleased at the recollection of our ceremony for the unveiling of Judge Brown's portrait, but I feel that he might be a little bit too close, and we feel he's part of our argument today, so I've just asked for him to be pulled back a little bit. Good morning. My name is Gabrielle Wolohojian, and it is my great pleasure to be sitting today with Justices Desmond and Sachs. We've only got one case this morning. We have the normal rules of oral argument in place. Each side receives 15 minutes to argue. There's no rebuttal. At about a minute and a half before the end of your time, the yellow light will go off so that you have a little bit of warning as to where you are in terms of the length of your argument. And when the red light comes on, your time is up, and you should stop unless we're continuing to ask you questions, which may very well occur. You may assume that we have read your briefs, large parts of the record, and we're familiar with the case. So you don't need to feel you need to educate us about the background, unless, of course, you wish to. You may structure your argument any way you want. And with that, I'm going to call the case. So it is, and it's partially impounded. I'm not 100% sure why it's partially impounded, but I assume there's some kind of financial information that at some point was impounded. But in any event, please be conscious of the impoundment and avoid referring to it in open court if you can. So with that, I'm going to call the case 2022 P1249, Gordon Harris versus Imaging Advantage. And is it Attorney Thomas?
Yes, Your Honor.
All right. We're ready whenever you are.
May it please the court. This appeal concerns three events that the trial court found to be liquidity events that triggered an exit royalty.
Would you please either adjust the microphone or don't forget to speak up as well?
Okay. Is this better, Your Honor?
It is.
Okay. Three events that the court found to be liquidity events under the party's main contract, the license and services agreement. I'll refer to that as the LSA today. I'll also refer to the corporate plaintiff as MGPO and my client as IA. Importantly for the appeal, the corporate plaintiff, MGPO, terminated the license and the LSA in March 2011. One of those events that the court found to be a liquidity event occurred pre-termination, two occurred post-termination. The trial court erred in granting summary judgment as to all three events, and I'll address each of those in chronological order. The first event was an investment by Goldman Sachs and a redemption by certain equity holders of IA. At the time, the court referred to this as the redemption. This transaction essentially gave Goldman 50% of the Class B units and allowed them to appoint 2 members to a 7-member board. When we look at the definition of liquidity event, and this is Appendix 3, page 249 to 250, in Section 3.3.2, there are 3 types of transactions or 3 types of events that could trigger some type of liquidity event and corresponding exit royalty payment: an IPO, some type of a share transaction, and an asset transaction. As the record reveals, there was no IPO. With respect to the share transaction, Goldman did get 50% more of the voting, of the Class B voting interests. That potentially looked promising for the plaintiffs in the beginning, but there is a carve-out. Any type of securities obtained from IA are not included in that percentage calculation under liquidity event, and all of Goldman's shares came from IA. So Clause 2, which is the share transaction, could not apply. However, the Superior Court considered the percentage of ownership and found a liquidity event under Clause 3, and that's the asset transaction clause. That was an error. Clause 3 concerns...
Why is that the asset transaction? Why don't you continue? I'm interested in the words relating to, but I'm sure you get that.
Yes. It's an asset transaction clause because it's the way it's written.
Why is it only an asset transaction clause?
Because it concerns the sale, a lease, a license, or other transfer of some type of ownership or material control rights in the assets, right, in the 3D assets.
Ownership of what? Ownership
Of the-
of control, ownership of rights relating to the 3D assets? What does ownership apply to?
It would apply to the assets.
Why, where's the word of?
It's in section 3.2. Hold on a second.
I'm looking at, yeah,
just
Clause 3, other transfer of ownership or material control rights relating to the
3D
3D
assets.
assets. So it doesn't say ownership of the 3D assets.
No, you're right. It doesn't say of, it says relating to. You're
Yeah.
correct. That's a correct reading of it. It's a type of transaction that concerns ownership or, again, sale, lease, or a license of the assets. It's not relating to shares.
If
Shares
there
is
was a
Clause 2.
100% transfer of stock to Goldman Sachs, right, so that they got 100% of the control, would you agree that that would satisfy this subparagraph?
If they got 100% of the control of the entire company and they could do whatever they want with the company and the assets, yes.
In other words, it fell within the carve-out for a transfer of stock from IA, so it doesn't fall within subparagraph 2.
Correct.
But, okay, so this is helpful to me because why is it that that circumstance would fall within sub 3, but the current circumstance does not?
The current circumstances would not fall in because there was no transfer of the ownership of the assets. So
But
they
in
only had
in my hypothetical, there wouldn't have been either. It was just a stock transaction in which 100% of the stock transferred.
Okay, so well, let me correct my statement then. It would not, Your Honor.
Why would 100%, why wouldn't ownership of 100% of the stock be material control rights relating to the 3D assets?
Because under Massachusetts law, ownership of shares does not give shareholders ownership of the assets.
Sure, but we are actually going to be looking at this language. So what I'm struggling with are two parts. It doesn't simply say sale, lease, license, or other transfer of ownership of the 3D assets. Instead, included in that phrase are the words or material control rights. And it doesn't use word, as Justice Sachs said, it uses relating to.
Correct.
So we have to deal with those.
Right.
If Goldman ends up owning 100% of the stock of the company, controls the board, controls the stock, I think let's assume that that would constitute material control of the assets.
Yes.
So why would 100% stock transfer not satisfy this subparagraph 3?
If we're to define material control rights, which is undefined in the LSA, as getting 100% of the voting interests, then yes, it would satisfy that.
Okay,
Correct.
so this is helpful to me because what I think then your argument reduces to is that this particular transaction did not involve enough control to constitute material control rights.
Correct. And we cite the operating agreement is in Appendix 4, 234 to 236.
Okay, well, this is something different than saying you need to have direct ownership of the assets itself to fall within subparagraph 3.
Right. If we're going to define material control rights, which we believe is ambiguous, if we're going to define it as receiving 100% of the stock, under that hypothetical, you're correct. Under the facts of the case, though,
You're saying this did not constitute material control.
Exactly. Exactly. And we actually provided in Appendix 7 at 450.
Would you agree that relating to is broader than of?
Would I agree that the phrase relating to? Is
Yes, in
broader
other
than-
words, it doesn't say ownership of the 3D assets. It says relating to the 3D assets.
So ownership relating to the 3D assets, is it materially different than the word of? I suppose it is. I'm not entirely sure what it means in the context of
We
this
have plenty of cases saying that it's an extremely broad term.
of. Or
No,
relate.
relating to.
Yeah, is it broader than of? I would suppose so. It is.
Okay, so then can you help me with the clause after the comma?
Including any such transaction involving
Yeah.
imaging advantage or Tele3D that
Yeah.
includes.
How
the
do we, if we were to accept your argument that this subparagraph only relates to a transfer of ownership, direct ownership of the assets, in other words, an asset sale or asset lease, how would we then understand the final clause?
I think it's indicating that potentially there could be a transaction to the extent, transaction. I'm not entirely sure, Your Honor. It looks like it is.
Wouldn't that seem to then, if we can't understand that clause within the context of accepting this as a provision relating only to a transfer of interests in assets themselves, wouldn't that tend to undermine the notion that this is an asset sale or asset transfer provision?
It is, I agree that it would probably go against that,
Yeah.
but we did find it ambiguous. We did present to the court in Appendix 7, page 415, an expert opinion on how these clauses are written generally,
Yeah.
and what happens in this type of transaction. And it was, the expert opinion is pretty clear that there is a share sale and an asset sale. That's typically how these are presented. So to the extent.
The expert testimony concerning whether or not an ambiguity exists admissible? I mean, under what rule of evidence is an expert permitted to opine on whether a contract language is ambiguous?
I don't think they can, Your Honor.
Right, so I didn't really see how that could come in and summary judgment be considered.
I think the issue was there's ambiguity in between Clause 2 and Clause 3, and we were presenting an expert opinion to basically deal with that ambiguity, and I think it does come in that regard. But you're right, the trial court would have to find, and this court would have to find 3.3.2, Clause 2 and 3 read together as a whole, as ambiguous, to look at that expert opinion.
We couldn't, okay, so let's assume for a moment, just, I'm not trying to express any viewpoint here, I'm just trying to get some sort of, in my head, decision tree, some map in my head of how all these different arguments relate. Were we to conclude that subparagraph 3 is ambiguous, what then happens? Like, what then in your view needs to be decided? I mean, then there would be 2 other liquidity events.
Right.
Is any one liquidity event enough? Yes, okay.
is.
Because
It
no
is.
one, I was so confused about that. No
It
one
is.
argued that there would be some consequence if we only found that one liquidity event had occurred. So I wanted to make sure, and I'll ask your brother this too, that just assume we were to find that there was, summary judgment was appropriate on one liquidity event, then that would be enough to affirm?
Correct.
Okay.
Absolutely correct.
All right, that's helpful too.
Okay. Moving to the post-termination liquidity events, so this is the dissolution of Tele3D in 2012 and the Envision purchase in 2000.
And I'm so sorry to interrupt you
That's okay.
again. I have one more question before we move from subparagraph 3. So I'm really struggling with the use of the definite article in this clause. So we have the 3D assets, mentioned
at-
twice.
Okay, you're looking at the first paragraph?
I'm looking at the exit royalty 3.3.2.3. I
Okay.
just say page 250 in the record.
Yep, no, I'm with you, Your Honor.
Okay. So the interesting thing to me is 3D assets is defined in the first sentence of exit royalty, but the definite article, the, is not part of the defined term.
That is correct.
Okay, so then it uses the definite article in subparagraph 3.
Correct.
Do you have an explanation for what the definite article then means? Because it's not just relating to 3D assets, it's saying relating to the 3D assets, but the 3D assets has not been defined.
Yeah, I think that's our point, Your Honor. And going back to 3.3, the first sentence, the LSA defines the 3D assets as the assets associated with the 3D services. And those aren't attached to or listed in the LSA. And that really, what assets were considered the 3D assets was a matter of dispute between the parties at summary judgment. And that's, I think, the problem with the next two liquidity events. Until that is determined, there cannot be a liquidity event based on a dissolution of Tele3D or the envisioned purchase, because the purpose of this agreement was to grant royalties based on a license, right? And that's right in Section 3, in consideration for the license, we're going to give these royalties. So the problem that and what we argued below, was that once MGPO terminated that license, right, and took away the LSA, which was the only thing of value, that anything that preceded that could not trigger an exit royalty because it lacked consideration. And that is consistent, we believe, with the reading of Section 7.6 on survival. Only those royalties accrued at the time of termination would survive termination of the LSA. And it does go back to the question of the 3D assets versus the 3D services. Those things were in dispute. And there were at least 3 or 4 alleged 3D assets that the court found. None of those were tied to MGPO's license IP. When Tele3D was dissolved, it didn't dissolve any assets. It didn't convey any assets to IA. The LSA and the license had been dissolved. There were no 3D assets to actually give. And that's why that second and third liquidity event, at the very least, should have gone to the jury. We need to define what the assets are that are associated with the 3D services, and what all of that means. So that's why those two liquidity events, we believe, were not appropriate for summary judgment. We also gave, again, an expert opinion on these issues as to what the assets were and what the services were in the context of this contract, because we did find it ambiguous. And I think that really is the nub of the next two, those post-termination liquidity events. At the time of the...
Your time has expired. Let me see if there are no questions. You do.
Yeah, I have a question about the cross-appeal
Yes.
and the attorney's fees issue. Can you give an example that would not render the second clause of that MGPO depends on superfluous? In other words, an example of a breach of some provision of the LSA other than a dispute between the parties that would give rise to a claim.
Sure. And this is under the attorney's fee provision, section 15.1, correct?
Yeah, well, yes.
Yes. For example, if some type of rights were violated as to a third party, and either MGPO or IA were responsible, and there was some type of a claim, that potentially could be something that would fall into that. And I think the important point on the cross appeal in opposing it is that there was a burden under the
Right, the clear and unambiguous.
Right.
But I want to get a specific example, if at all possible, of a claim that would be based on or arise out of a breach of some provision of the agreement.
Well, use of
that would not involve a dispute between the parties.
maybe using MGPO's mark or something, or using some type of asset that triggered a copyright claim or a patent claim or something like that.
So who would be the third party who would be suing?
It would be the third party that claims that they own the asset or the IP or something like that.
Well, MGPO has rights to the mark, don't they?
They do, and they, but marks are challenged all the time, so aren't IP. I mean, if the 3D post-processing services are patented or something like that and they're IP rights, others can challenge that.
And is that a claim arising based on or arising out of a breach of the agreement, or is that a claim based on, patent or trademark law?
It could be based on the breach of some kind of covenant or representation in the agreement that I own this IP, this is my intellectual property, something like that. So there could be third-party claims brought against either MGPO or IA that are unrelated to a breach of the agreement. I'm sorry, that are related to the breach of the agreement, Your Honor.
It doesn't say related to, it says based on or arising out of.
Correct. I don't see a material difference between that, Your Honor. I mean, there can be third-party claims brought based on either party's breach of this agreement that would fall under that clause. But again, we could read the clause as a whole. It does give either party the right to defend and provide evidentiary support. That's why I think the Superior Court judge said this is not enough to shift fees.
Okay.
What's I have a hard time understanding the defend language in the context of a suit among the parties to the contract over a breach of the contract.
That's right.
How would that work?
That's our point.
Yeah.
That's why there can't be first-party claims against each other, because otherwise, MGPO could bring a claim for breach against IA. MGPO would be required to provide defense
Right, but
to that
that doesn't mean that the remainder couldn't be, we couldn't make sense of the remainder, indemnify and hold harmless within that context.
I'm sorry, Your Honor, I'm not following.
In a suit between the parties over a breach of this contract, alleged breach of this contract, the words indemnify and hold harmless could be logically intended, correct?
Correct.
Okay.
Right, but includes defend and the other portions as well. I think that falls under sort of that Prosky case and the other one from the SJC.
Let me see if there are further questions. No? All right, thank you. Your time is up.
Thank you.
Is it Attorney Carister?
It is, Your Honor. Good morning, and may it please the Court. My name is Dale Carister. I represent Massachusetts General Physicians Organization and Dr. Harris. Given the limited amount of time, I intended to focus my argument on Imaging Advantage's appeal. Any time permitting, I will then briefly address the cross appeal with respect to the denial of the motion for attorney's fees. Your Honor, the Superior Court correctly granted summary judgment because it properly determined that there were in fact no genuine issues of disputed issues of material fact. It properly determined that the contract provisions were not ambiguous, and it properly determined that MGPO and Dr. Harris were entitled to judgment as a matter of law in that Imaging Advantage breached two basic obligations, one of which was the obligations to pay the exit royalty and the exit payment, which is the subject of the appeal, and also that it breached Section 9 by virtue of the misuse of the MGPO and MGH names. And as to the latter, my understanding is that's not the subject of the appeal. It is obviously a contract interpretation case. It concerns comprehensive, detailed, and lengthy agreements by and between sophisticated parties. MGPO not only provided a grant of licenses to imaging, to Tele3D, and also the right to use certain names and marks for a certain period of time, but also MGPO and Dr. Harris agreed to and in fact provided services to Imaging Advantage and Tele3D, including not only the rendering of 3D post-processing, but also services in connection with Imaging Advantage securing its initial customers and investors. In fact, Dr. Harris participated in a due diligence meeting with Goldman Sachs shortly prior to the investment.
Can we focus on the language of the third liquidity event, which we spoke about quite a bit with IA? Could an entity have material control rights relating to assets without owning more than 50% of the voting power of the shares that own those assets?
Yes, and I would direct the Court's attention to Section 5.4 of the LLC agreement, which gave Goldman Sachs effectively a veto power over the very nature of the business of Imaging Advantage. This is something that's largely been ignored by Imaging Advantage, but under Section 5.1 of that LLC agreement, Imaging Advantage provided that the board's control was subject to Section 5.4. And under Section 5.4 of the LLC agreement, the Goldman Sachs was given effectively a veto power where there was, in fact, even the liquidation of Tele3D could not have been done without the written consent of Goldman Sachs. They could not alter or change the nature of its business without the written consent of Goldman Sachs. So I think in that instance, Your Honor, absolutely, that level of control was provided to Goldman Sachs pursuant to that Second Amended Operating Agreement, which was put in place in connection with the Goldman Sachs investment.
And can you tell us what the word ownership applies to that later in the sentence?
In the clause, subclause 3?
Yeah.
Correct. The ownership is broadly referred to as not limited to 3D assets, but it effectively would include any ownership of the entity itself, Imaging Advantage.
Well, I'm not sure how that emerges out of the language of Clause 3. I'm asking maybe a grammatical question. What does the word ownership, what words after the word ownership in that clause does ownership apply to? Ownership of what? Ownership relating to what? What does ownership mean?
So it's extraordinarily broadly and expansively worded to refer to the ownership of anything relating to the 3D assets. So in other words, so long as the entity itself has 3D assets, then any transaction involving Imaging Advantage that included the 3D assets would be included. And that's the meaning of that final clause that Your Honor was directing the attention to previously.
Does that clause expand the scope of subparagraph 3? It just says including any such transactions involving IA or Tele3D that include the 3D assets. But it doesn't, if it expands, tell me how.
I think it's actually confirming the breadth of that language. In other words, and we can't disregard that clause. So in terms of principles of contract construction, I think that clause is confirming the breadth of that which precedes it.
Do you think it is giving an example of what is the relationship between that clause and the meaning of the clause before it?
So
Is it a subset? Is it an example? What is it?
So first I would point out that this is not what Imaging Advantage has tried to point out as being some sort of a standard corporate transaction. In this instance, MGPO and Dr. Harris did not receive any equity in this startup entity. Instead, they were provided with what Mr. Nasir Hashim had referred to as a workaround, in that the exit royalty and the exit payments were workarounds to receiving equity. So it's not a standard transaction.
I understand that, but it could still result in an ambiguous contract language.
Well, Your Honor, I would submit that under Clause 2, the reason for disregarding the shares directly acquired is that typically that investment is going to make the pie bigger for the benefit of all of the equity holders. Here, Clause 3 provides additional protection for MGPO in that because they're not an equity holder, they have a broader language and more expansive language in Clause 3. And an example of a situation would be to the extent that an investor comes in, invests, and without, assume for a moment, without any kind of redemption of interest, they invest, and instead they have some type of a carve-out whereby they are not given any ownership or control rights relating to the 3D assets. In other words, they're almost like spinning them out, which is a concept that's contemplated throughout Section 3.3 on the exit royalty provision. And so you could have something similar to a Section 5.4 of the LLC agreement, but carving out things related to the 3D assets, so such that the disregard of language of Clause 2, the Clause 3 wouldn't render that meaningless under Clause 2.
Can you shed some light on the use of the definite article?
Yes, in response to Your Honor's question earlier, I think we need to look to the definition of 3D assets appearing in the first sentence of 3.3.
I know, but the word "the" is not included within the defined term.
So I think what it's referring to, Your Honor, is that in order to qualify sort of as 3D assets, it's all or material component of the assets associated with the 3D services. So I think by use of the word "the," it's referring to sort of all or substantially all of. So as opposed to just simply if you shed, transfer a particular 3D asset. So my understanding is that the use of the word "the" is really referred back to the language as how it's defined in the first sentence of 3.3.
Right, but that's my question, because it's not defined with the word "the" in the first sentence.
The isn't in quotation marks, in other words. I think it's
Correct. I mean, it is not, although it appears immediately outside the quotation marks, since it says
is.
such assets are as the.
Right, but being outside the quotation marks, don't we have to assume that's deliberate?
Yes,
Okay, so it's not part of the defined term.
correct.
And so then, what meaning does it have when it's used as a definite article in subparagraph 3?
Your Honor, again, I think when by use of the word "the," it's referring to all or substantially. So in other words, it's not just a transaction that includes any 3D asset. I think the use of the word "the" means you need to refer to something more, all or substantially all of.
And you get that definition from the dictionary, or where?
No, from the use of the language in the first sentence of paragraph 3.3, where it's referring to all or a material component of the assets.
Can you talk about I didn't notice any argument in your brief concerning the purchase by Envision.
I believe we did address that in our brief, Your Honor. That would be the third liquidity event.
Right.
And Your Honor correctly noted before that any of the three liquidity events constitutes a trigger obligating the payment of the exit royalty. We're not contending that they'd be obligated to pay more than one. And as to the third event, that issue simply boils down to whether they did or did not have any 3D assets at that point at the time of the transaction. Imaging Advantage doesn't dispute that transaction, the $217 million transaction by which the founders and the unit holders and investors all cashed out, they agree that constituted a liquidity event under Clause 2 if they had 3D assets. They are disputing whether they did have 3D assets. And as Judge Green properly found in the Superior Court's decision, they in fact had many 3D assets and really only need to look to their Imaging Advantage's own admissions. So by way of example, they admitted that the contract with 3DR Labs, a competitor of MGPO, constituted an asset associated with the processing of 2D images into 3D images. So there are numerous admissions that are referenced in the Superior Court's decision by which it properly noted that, in fact, there were 3D assets at the time of the acquisition by Envision.
And where is it that we would so what I see as the definition of 3D assets is a component, all or a material component of the assets associated with the 3D services. There's no definition of asset there. and component, at least to my mind, seems to suggest something physical, tangible, as opposed to a legal entitlement. Is there anything in here that would shed light in the document as to the meaning of the word assets in the first sentence of 3.3?
So the word assets is not defined within the LSA, but, Your Honor, I would direct the court to the numerous admissions.
Which admission? Can
So-
you give us the page number in the record?
Sure, one moment, Your Honor. So I would direct the court's attention to the statement of material facts, and that appears in Volume 1 of the Record Appendix, starting at page 182. And, Your Honor, I would actually note in connection with those things, the Superior Court properly noted that not only were many of these facts admitted as undisputed, but to the extent that there was an attempt to controvert those facts, most of the times there was no actual citation to record evidence to dispute that. And
So which is the admission where they say, yes, we admit we had
so
assets?
to be clear on a number of these, Imaging Advantage would try to dispute whether it had a capital 3D, capital A 3D asset, or that something was in connection with capital S 3D services. But they in fact admitted that their contracts with, for example, St. Joseph's and 3 of the other hospitals constituted an asset associated with the rendering of 3D services.
So where are those admissions?
So, Your Honor, I apologize for not having those at my fingertips, but
you're saying that an admission that ties directly to the language as opposed to the defined term, but to the language of the first sentence of 3.3.
the language that appears within the definition itself, correct.
Okay.
So there were numerous instances, for example, in the response to the request for admissions, and whereby they would attempt to draw a distinction between the two. And the response to the request for admissions appear in Volume 2 at page 164. And if you just give me one moment, Your Honor, I'll direct your attention to certain of those admissions.
I don't mean to, we can find this. I don't want to consume your remaining.
Sure, Your Honor, and there are numerous instances, and we cited these in our consolidated statement of material facts and in our briefing, but these admissions are largely based on the responses to the request for admissions, interrogatory answers, and deposition testimony, for example, of Mr. Hashim. And if you look in the consolidated statement of material facts, they generally did not cite to any countervailing evidence to try to dispute the actual statement in the material facts.
Can we turn to your, well, let me see if there are any questions on what we've covered so far.
Well, I do want to get to the termination clause, section 7.6, but I don't know if that's before
No,
or
that's,
after.
that's fine.
Okay, so 7.6, you say that the parenthetical phrase, to the extent of royalties, fees, and expenses accrued through such time, is limited to modifying 5.1, 5.2, and 5.3.
Correct.
I could understand if you said it was limited to 5.3 under the so-called rule of the last antecedent, but instead you're going back further in the sentence. You're saying it applies not just to 5.3, but also to 5.2, 5.1. It seems kind of arbitrary to stop there and not go back 2 more citations to section 3, which directly covers royalties. Yeah,
the difficulty with that is that in between And the reason why we referenced in the way in which we did is because of the references to royalties, fees, and expenses in 5.1, 5.2, and 5.3. In other words, there is some tie-in.
Sure, but Section 3 is all about royalties as well.
It is, but there is no parenthetical after it. And I would also note that in between the two refers to a Section 4.4.1, which is entirely unrelated. And so, in other words, there would be no basis to sort of run it through that it somehow modifies the earlier ones. And you note before that there is a parenthetical modification immediately after paragraph 2. So the way in which this is drafted, you have parentheticals modifying that which immediately precedes it. And here you have Section 4.4.1 reference between paragraph 3 and the paragraphs 5.1, 5.2, and 5.3.
Is your contention that the first parenthetical modifies only Section 2?
Correct.
And the second parenthetical modifies 5.1, 5.2, and 5.3?
Yes.
All right. Those two positions, with all due respect, seem hard to reconcile to me because perhaps if you said 5.2 and 5.3, which are not separated by a comma, that might be okay, but I'm struggling with Judge Sachs' question as well.
So the reason why I've taken that position simply is because of the references in 5.1, 5.2, and 5.3 tying into royalties, fees, and expenses. But in any event, I think it's very clear it does not apply to paragraph 3. And had the parties intended to have that language modified, they could have put it in after paragraph 3, but they didn't. And the sections of paragraph 5 generally relate to the billing for these various components.
Do we need to look to the party's intent in order to determine whether the parenthetical applies to paragraph 3?
No, I think you can look directly to the language itself.
Okay, and if we can't, then do we need to? If we were to determine that from the language itself you can't tell, then what?
Well, I think you can get indicias of intent from other provisions in the agreement. So by way of example, an interpretation that somehow modifies that would render Section 3.3.5 meaningless. Section 3.3.5 applies in an instance in which there has been a dissolution of Tele3D, a liquidation of 3D assets. And that language, wouldn't have, that section wouldn't have meaning to the extent that the qualifying language were to be deemed to be applied to paragraph 3. So I think you can get indicias of intent from reference to other provisions within the LSA.
One other question about termination. In your brief at page 46, you cite to a settlement agreement dated November 21st of 2011 in which IA and Tele3D acknowledge post-termination that the obligation to pay the exit royalty upon a liquidation event is one of the rights that expressly survives termination as set forth in 7.6. That's at Record Appendix 10, page 112. I'm curious why you don't make more of that, if that really is binding here. I see that it's only signed by IA and Tele3D, not MGPO, but why doesn't that play a larger role in your argument?
Well, Your Honor, we were pointing to the contract first and foremost, and then secondly, directing the court's attention to the extent that there were interpretations that were being proffered that were contrary to admissions and other evidence. In other words,
do you contend that that settlement agreement is binding, or was it never signed by MGPO?
It was signed, and my understanding was that the countersigned page was included within that exhibit. I may be mistaken on that, but it was fully executed by both parties. And
okay, you're right, it is.
And as far as that's one of the documents that's been impounded. It was impounded at the request of Imaging Advantage. But I would direct the court's attention not only to the settlement agreement, and we really undertook to direct the court's attention initially to the contract terms itself, and then to the extent that there were interpretations that were being proffered, they were unreasonable in that they contradicted their own admissions in course of dealing. And not only that 2011 settlement agreement, which was months after the termination of the licenses and the LSA, but in addition, the July 2012 letter from Imaging Advantage itself expressly stated they were issuing this notice in accordance with Section 3.3.5 And lest there be any doubt, in April of 2017, their attorney, in response to a demand letters that were issued on behalf of MGPO and Dr. Harris when they became aware of this impending transaction with Envision, sent the letters in, I believe it was in March 2017. In a response letter, counsel for Imaging Advantage referred to first the clear provisions of the LSA and further identified that those provisions were unambiguous. In other words, positions entirely contradicted by what they're asserting now, but went further to say that.
Isn't this essentially parole evidence that can't be considered here?
No, I think, Your Honor, it's appropriate to consider it in the context of whether the proffered interpretation is reasonable or not. Similar to if they're proffering an affidavit that contradicts.
You mean it's okay to confirm an interpretation, but it's not okay to contradict an interpretation?
Well, I think it's really just limited to the context of the courts considering the reasonableness of a proffered interpretation. And can it be a reasonable proffered interpretation if it is contradicted by your own admissions and conduct? And in this instance, I would suggest that it is unreasonable in that they expressly stated in that letter that the dissolution of Tele3D and the notice fully complied with the provisions of Section 3.3.5, and more than 4 years have passed during which neither Imaging Advantage nor its affiliates or assigns rendered 3D services. And then, quote, thus, any obligation to pay an exit royalty has expired. In other words, all of the arguments they're making now about the license termination somehow having some impact are contradicted by a letter from their counsel submitted 6 years after the the termination of the agreement and the licenses, and they are pointing again to Section 3.3.5 and saying that's the reason why. Their purported compliance with Section 3.3.5, by which he had, broadly asserted that they hadn't rendered 3D services and that they didn't have 3D assets. All of this, I think, boils down to, again, to the efforts to rewrite the contract definition terms of 3D services and 3D assets. It's at the heart of every argument that's being made. But to respond to your initial question, we thought most appropriate to direct the Court's attention to the contract provisions, but then further assert that the proffered interpretations are contradicted by their own admissions and conduct. It's much like if somebody submits an affidavit in opposition to a motion for summary judgment that purports to create a disputed issue of material fact when there's sworn deposition testimony indicating to the contrary. I realize I am out of time.
I have, unless.
Go ahead.
I'd like to turn to the guarantee and the consulting agreement. To begin with, I just am puzzled by what is it that you contend is the amount owed under the consulting agreement.
I'm sorry, I couldn't hear part of that, Your Honor.
Sorry, what is it that you contend is the amount owed under the settlement, under the consulting agreement?
So under the consulting agreement, it had various components of compensation. And buried within the schedule attached to the consulting agreement were so-called fee deferral, which had a very complicated and somewhat convoluted way of calculating the amount that would be due, but it referred to the $750,000 amount. And Imaging Advantage has admitted that the letter agreements were intended to simplify and clarify the compensation provisions that appeared in that. And what they did instead was simply, instead of these various calculations that appear in that schedule to the consulting agreement, they instead agreed that upon a liquidity event, you shall receive $750,000.
That's all that Harris is looking for at this point. Is that
Correct.
it? Okay.
Yeah, the $750,000 amount, correct.
Okay, and then can we talk about the guarantee? First of all, what is your best case for the proposition that there can be a guarantee of a future payment of unknown amount or extent, in the future? Do you have a case saying, sort of giving parameters or saying that that's okay, not okay? What are the limitations maybe on that?
Well, I don't have a specific case, Your Honor, but
Is there any case where we've said an unlimited guarantee of unknown future amounts is enforceable, regardless of the amount, the circumstances? In other words, it's just enforceable, regardless of what comes up?
I'm not aware, I apologize, Your Honor, I'm not aware one way or the other.
So how is it then, but that's essentially what you're asking be accepted here, no?
I don't think so, Your Honor, in the sense that they were guaranteeing the obligations for the compensation provisions, and then they agreed to simplify and modify those to provide that upon a liquidity event, that they would guarantee that payment. And the guarantee, I think it's simply a matter of contract interpretation, and the guarantee itself expressly states that it guarantees any amendment or modification of the guaranteed obligations. The guaranteed obligations included the compensation.
But how was, excuse me, the April letter agreement terminated the consulting agreement? It didn't say it amended or modified it.
Correct. The guarantee language went further than that, Your Honor. In
Right,
that,
and how did that, I see the guarantee is supposed to survive any termination of the consulting agreement, but can we construe that as going beyond obligations that had accrued at the time of the termination of the consulting agreement? Otherwise, it's perpetual.
well, Your Honor, I think, again, it's really, it's a guarantee of the guaranteed obligations. And so those guaranteed obligations were the compensation provisions. And the guarantee language guaranteed that they would make payment, of those. And
Right, but the $750,000 obligation in the letter agreement is not precisely the same as the obligation in the consulting agreement. It was modified, and it was limited, as you say.
Correct.
So it's not the same obligation as was in the, as was guaranteed, it seems to me.
it was an amendment of that obligation. And it...
All right, but how can it be an amendment if the, I think we're going in circles, unfortunately. If the consulting agreement was terminated, not merely amended, then how can you consider that an amendment?
So I would first point to Statement of Fact number 15 and our consolidated Statement of Material Fact, by which Imaging Advantage, it was undisputed, and they admitted as follows: the parties entered into the March 12, 2010 and April 30, 2010 letter agreements for the purposes of simplifying, clarifying, and shortening the compensation provisions of the consulting agreement.
That's not inconsistent with the question, though, that Judge Sachs has posed, because the letter agreement says that it's terminating the previous agreement.
Correct. I would also...
That makes that is a simplification in some ways, but it does say that it's terminating the previous agreement.
Correct. And in effect, I think it might be sort of form over substance, in the sense that what the parties were doing is to say, we are going to take this more complicated calculation of compensation of the consulting agreement and shorten it. And I think it's also pertinent to note that this was all done right at the time leading up to the Goldman Sachs transaction.
Okay. So I also then have a question about the language under the foregoing consulting agreement in the guarantee. So to me, that refers to the consulting agreement above the guarantee. How do we then export that obligation to the subsequent letter agreement?
Well, Your Honor, I think, again, just by looking to the language of the consulting agreement, of the guarantee itself, where it said the guarantee was of the guaranteed obligations, including the compensation provisions.
Well, it says under the foregoing consulting agreement.
Correct. Right. But it's confirming that it's, any amendment or modification of those. And, I think in effect what it was, whether we use simplify or clarify, but at the end of the day, it constituted a modification or amendment of those obligations. And I would also direct the Court's attention to the fact that Mr. Hashim he was the one who executed the guarantee and the letter agreement, affirmed that Imaging Advantage had entered into those agreements and had agreed to pay the $750,000 to Harris if an exit royalty was due to MGPO.
What are we supposed to do with that where the letter agreement is clearly signed by him on behalf of Tele3D only?
Well, I would note, I think there's a reason why he acknowledged that it was actually Imaging Advantage that it entered into. On the letterhead, first of all, it refers to Tele3D in care of Imaging Advantage. And also there was evidence submitted as part of the summary judgment record that their own witness testified that Tele3D was a ghost. And I'm frankly kind of surprised that they're even making this argument about the guarantee, because it suggests that, without ever capitalizing Tele3D, that they entered into a separate obligation. And there was actually, I think the Superior Court noted some of the facts pertaining to that. But their own witness testified that Tele3D was a ghost. But it was the same individual who was president and CEO of both who signed and who testified that it was Imaging Advantage who had entered into these agreements.
So, again, is that parole evidence that varies the meaning of, if I just look at the April 30th or the as of April 30th letter agreement, it's signed only by Tele3D Advantage.
Right, but I think
the fact that the same person is also CEO of Imaging Advantage and that they share an address, what does that have to do with interpreting the language?
Well, I think it's even stronger than that. It's actually an admission.
Doesn't it vary the language of the letter agreement?
I'm sorry, Your Honor?
Doesn't it vary the language of the letter agreement to say, oh, he admitted he was actually signing on behalf of Imaging Advantage? That plugs the words Imaging Advantage into his signature block.
Well, first of all, that the fact itself is undisputed. It appears at Statement of Material Fact number 17.
Oh, I understand that he admitted that, but I'm asking how can we consider that in interpreting the document itself?
Well, I think it
When
goes...
the document shows no such thing.
Right. So first of all, I mean, we brought claims on, on the guarantee of the obligation, but my point in making this is that he admitted the underlying obligation to pay this, Imaging Advantage's obligation to pay the $750,000 to Dr. Harris if there was an exit royalty due to MGPO. I mean, so at the core of the matter, we have an admission which is undisputed by Imaging Advantage, and again appearing at number 17 of the Consolidated Statement of Material Facts. So, it's more than just a matter of on whose behalf it was signed and so forth, but they're acknowledging, Imaging Advantage was acknowledging that it was obligated to pay the exit payment to Dr. Harris if it was obligated to pay the exit royalty to MGPO.
All right, let me see if there are any further questions. No. All right, I think we're going to have to leave it there.
Okay. Thank you very much.
Interesting case. We were very much helped by your briefs and by your arguments, and the case is submitted. That ends our sitting for today, and we are adjourned.